The following is a dramatization with volunteer actors. All characters and case information is fictitious. Any similarities to real-life individuals or real cases is unintentional and strictly coincidental. This video is for informational purposes only.
Hello and welcome. Today we'll be talking about your family law court case, and specifically, what happens after you go to court. By now, you already know that you have to complete judicial forms to have your case heard in court. But did you know that you have to complete judicial forms after your court hearing and trial? We're going to talk about what you'll need to do after going to court, the different types of court orders, and what can happen if the court orders are not completed.
Mr. and Mrs. Baker, I've heard all of the evidence today, and I have found that it's in the best interest of your son Jeremy for the two of you to share joint legal custody. This means that you need to work together to make decisions regarding Jeremy's health, education, and welfare. And I find that joint physical custody is in his best interest. His primary residence, though, will be with Mrs. Baker. Mr. Baker, you will be getting visitation. Your visitation will be on the second and fourth weekend of the month from Friday at 6 p.m. to Sunday at noon. Your weekends are defined by the Fridays. Do you have any questions?
No, Your Honor.
Mrs. Baker, do you have any questions?
No, Your Honor.
Good. And Mrs. Baker, you're the petitioner in this case, so you need to complete the findings in order after hearing. This court's adjourned.
Well, it looks like you got your way. I'll be there on Friday to pick up Jeremy.
6 o'clock, right?
Whatever. Didn't the judge say you should get your order done?
Yeah, I think so. Not now, though. I'll have Jeremy's bag packed and ready on Friday, okay?
Fine.
Like many divorced or separated parents, Lucy and Rick Baker needed the court to decide who their son would live with and when the other parent would have visits. After making her decision, the judge instructed Lucy Baker, the petitioner, to prepare the findings in order after hearing. The court clerk prepares a minute order shortly after the hearing. A minute order is a record of the orders the judge made during the hearing. A findings in order after hearing is a formal order prepared by one of the parties and submitted to the court for the judge to sign. The findings in order after hearing sets forth the orders made by the judge, and the minute order may be used to prepare the findings in order after hearing. If you need help in preparing the order, you may seek assistance from the Self-Help Center in the Law Library on the 3rd floor of the Superior Court Building, located at 1415 Truxtun Avenue, or from the Family Law Facilitator's Office on the 1st floor of the Superior Court Building, located at 1215 Truxtun Avenue. The findings in order after hearing is submitted to the court at the Family Law Clerk's Office. It is sent to the judge for review. Remember to submit the original and one copy of the findings in order after hearing, so you will have a filed, endorsed copy. If the findings in order after hearing accurately states the judge's decision, the judge will sign it. This signed findings in order after hearing is enforceable. Here, both parties were in court. They both heard the judge's decision that Jeremy would live with Mrs. Baker and have visits with Mr. Baker on specific days and at specific times. Although these orders are effective immediately, in the event of a dispute, the parties would not be able to obtain the assistance of law enforcement to resolve the dispute unless they had a filed, endorsed copy of the findings in order after hearing. Let's take a look at what happened 6 months later when Mrs. Baker still had not prepared the findings in order after hearing.
What's wrong, Lucy?
It's 2 o'clock, and Rick isn't even answering his phone. He was supposed to bring Jeremy home by noon.
Does he ever bring him on time?
No? I'm so tired of it. And lately, Rick has been such a jerk. He got some job offer in Arizona, and he threatened to move there with Jeremy.
Didn't the judge say that he's supposed to be living with you?
Yeah. I'm gonna try to call him again.
Okay.
Rick, you're 2 hours late, and Jeremy has homework due on Monday. You're where? Arizona? Rick, you can't just take our son like that. You need to bring him home immediately. That's it. I'm calling the police. Rick? Rick? He hung up on me.
Oh, Lucy, you need to call the police right now.
Hello, my name is Lucy Baker and I live on 555 Right Heart Way. My ex-husband has abducted our son and taken him out of state. I need an officer immediately.
Hello, good afternoon. Are you Lucy Baker?
Yes, I am.
I'm Investigator Fairman. What seems to be the problem today?
My ex-husband was supposed to bring our son Jeremy home by noon. He has weekend visitations, but our son lives with me. I got a hold of him around 2 o'clock, and he said that he had moved to Arizona with our son, and he wasn't going to bring him back.
Okay, Mrs. Baker, you said that he has weekend visitations and Jeremy lives with you. Is that correct?
That's correct.
Is that what the court decided, Mrs. Baker, or is that just a verbal agreement with both of you?
The court decided it. About 6 months ago, my ex-husband and I both went to court. He heard exactly what the judge said.
Can I see your court orders?
Orders?
Yes, your findings in order after hearing. Are they signed by a judge?
No, but the judge said it.
Sorry, Mrs. Baker. Unless you have orders signed by a judge, there's nothing that we can do to help you.
But he took off with my son. What am I supposed to do?
You need court orders. Without the findings in order after hearing signed by the judge, there's nothing for us to enforce. Once you have those documents, give us a call.
Thanks a lot.
Had Mrs. Baker completed her findings in order after hearing, Investigator Fairman would have been able to make a police report and begin to take steps to have Jeremy returned to Mrs. Baker. Without the findings in order after hearing, there were no orders for law enforcement to enforce. There are also other types of orders. In some cases, a judge may issue a judgment after a trial on the issue of paternity or dissolution of marital status, which is a divorce. Let's go back into the courtroom and see what happens when the judgment is not completed.
The court finds that irreconcilable differences have arisen, causing the irremediable breakdown of your marriage. Your judgment of dissolution is granted. I am now restoring you to the status of unmarried persons. Mr. Kern, you're the petitioner. I need you to prepare the judgment of dissolution of marriage. This court's adjourned.
Richard, that means we're divorced, right?
I think so. Are you coming to pick up the kids this weekend?
I don't know yet. I have to get my work schedule.
Okay. We'll try to call before Thursday.
Richard, don't forget, the judge said you have to do the judgment.
Yeah, I got it.
We just met Richard and Elizabeth Kern. If you recall, Richard was directed to prepare the judgment of dissolution by the judge. If you need assistance in preparing the judgment, you may seek help from the Self-Help Center or the Family Law Facilitator's Office. When preparing a judgment, it's important to remember that you must prepare a judgment and a notice of entry of judgment. You must provide the original forms as well as 3 copies of the judgment and notice of entry of judgment. You must also provide 2 envelopes with stamps. One envelope must be addressed to you, and one envelope must be addressed to the other party. After the judge signs the judgment, a copy will be mailed to you, and a copy will be mailed to the other party. Let's go back and visit Mr. Kern 3 years later to see what happened after Mr. Kern had still not prepared the judgment.
Are you number 22?
Yes, here's my number.
And what is your name, sir?
My name is Richard Kern.
Okay. And Mr. Kern, what can I do for you today?
Well, I'm in the military and I just received my new assignment. I'll be stationed in North Carolina and I need to relocate there with my children and new wife. My children are from a previous marriage and I have joint physical custody of them, but they live with me.
Okay. Would you happen to have your case number with you?
Yes, it's on this paper.
Okay. Let me go ahead and look up your case.
Thank you.
Mr. Kern, did you say you were remarried now?
Yes, I remarried last year.
Mr. Kern, there was never a judgment entered in your divorce case with Elizabeth Kern. The minutes from your last hearing state that you were supposed to enter your judgment. Do you recall that?
Vaguely. Is it a problem that I didn't do it?
Well, yes, Mr. Kern. Unfortunately, because the judgment was never entered, your marriage to Elizabeth Kern is not terminated. You're not divorced from her, and your new marriage is void.
What?
Because Mr. Kern never completed his judgment, his new marriage is void. A judgment signed by the judge and entered is necessary to terminate a marriage. Had Mr. Kern completed and submitted the judgment and notice of entry of judgment, he would have been a single man when he married his new wife, and his new marriage would have been valid. Because Mr. Kern did not complete the judgment to terminate his first marriage, additional legal steps and hearings will be necessary to terminate the marriage with Elizabeth Kern and make his new marriage valid.
Ms. Garcia, I'm going to grant the restraining orders that you've requested on the same terms and conditions as the temporary domestic violence restraining orders that you filed, except I'm excluding your daughter Veronica from those orders. I am granting the custody and visitation orders that you requested. These orders will be good for 3 years. You need to prepare a restraining order after hearing. I'm going to give you a referral sheet, and I need you to take that referral sheet to the Family Law Facilitator's office. They will help you prepare the restraining order after hearing. Do you understand?
Yes, Your Honor.
Good. Mr. Garcia, you are restrained from contacting or being within 100 yards of Ms. Garcia or her residence. Do you understand?
Yes, Your Honor.
Good. And Mr. Garcia, as part of this restraining order, do you understand that your mother, Veronica's paternal grandmother, will be providing all transportation for visitation with you and your daughter, outside or away from Ms. Garcia's residence? Do you understand?
Yeah, I got it.
Good. Are there any other questions?
No, Your Honor.
This court's adjourned.
Hello? Jack, you can't call me anymore. No, you can't come over. I have a restraining order against you. Stop calling me from blocked numbers. You're where? Here? That's it. I'm calling the police.
Come on, Jill. Open the door. This is my house.
Hello? I need an officer at my home immediately. My ex-husband's outside my door, and I have a restraining order against him.
Jill, open the door.
He keeps calling and threatening me. Please send someone quick.
Come on, Jill.
Yes, my doors are locked, but please send someone quick.
Good afternoon. I'm Investigator Fairman.
Hi, I'm Jill Garcia. I'm the one that called. Thank you for coming. Please come in. My ex-husband just left, but he keeps calling and threatening to come back. Our daughter's at school right now, but even for visits, he's not supposed to come near me or my house. Here's the restraining order I took out against him.
Mrs. Garcia, this is a temporary restraining order and it expired about a month ago. I did check the Department of Justice registry on my way here and I did not find a permanent restraining order after hearing. Do you have a restraining order after hearing?
Well, I haven't gotten one yet, but the judge did say that everything was exactly like in here.
Mrs. Garcia, without a restraining order after hearing signed by a judge, there's nothing for me to enforce.
But he keeps calling me and threatening me. He even parks outside my job. It's so frustrating.
I understand your frustration, but you need to get a restraining order after hearing signed by a judge immediately.
Domestic violence restraining orders also require paperwork to be filed after the hearing in order to make them effective for enforcement. If you have been granted a temporary restraining order, it is only valid until the hearing. If at your hearing the judge grants the restraining order, you will need to complete and file a restraining order after hearing. These forms must reflect the orders granted by the judge at your hearing. Once the restraining order after hearing is completed and filed, it is signed by the judge and can be returned to you, usually within 48 business hours. By now, you may have some questions about findings and orders after hearings, judgments, or restraining orders after hearing. Here are a few of the most common questions concerning orders and the answers.
If I didn't do my findings in order after hearing, right after my hearing, is it too late?
No. While Jill Garcia could have saved herself a lot of time and grief by completing her order soon after her hearing, it's not too late to complete her findings in order after hearing. Ms. Garcia should complete and submit to the court her findings in order after hearing as soon as possible.
What if the party that was ordered to complete the findings and orders after hearing or judgment refuses to do it?
Mrs. Kern brings up a common problem. Not everyone is going to be happy with the judge's decision. It is still important to have the orders completed. If the party who is ordered to complete the orders refuses or fails to complete the orders within a reasonable time, the party who was not ordered to complete the orders may still complete them. It's important to remember that the judge's decision was made to solve a conflict or problem, and each party should make a good faith effort to abide by the decision.
How should I use my orders, and how are orders enforced?
Here are some helpful tips on how to use and enforce your orders. Helpful ways to use and enforce your orders are: ask the other party to comply with the orders. Keep copies of your orders with you. Document violations of the orders, including the date, time, and what happened. File an incident report with local law enforcement. Only use legal procedures to enforce your orders.
Is there a wrong way to use the orders?
Yes. You should never attempt to alter the orders or twist the meaning of the orders to your favor. You should also never encourage anyone else to break the orders. Remember, court orders are to be taken seriously. The orders become law for the parties bound by them, and breaking the orders means you are breaking the law. While you may not agree with the judge's orders, the orders exist to stop or prevent future conflict. Here are some things to consider when reading your orders. Be reasonable. Focus on the children's needs. Give the orders a chance to work and give the other party the chance to co-parent. Ask, can any conflict or disagreement be resolved with peaceful and respectful communication with the other parent? Perhaps you can write a stipulation to change the orders that aren't working for you. Before you file for another hearing, consider, has there been a change in the circumstances since the last court hearing? Will great or irreparable harm or danger happen to you or the children if you go by the current orders?
What do I do if our children don't want to visit with the other parent according to the order?
Encourage your children to abide by the court-ordered visitation. It is in the best interest of your children to have the care and emotional support of both parents. If both parents work together to raise the children, visitation can be a positive and healthy experience for all parties.
What if I don't agree with the court orders?
First, give the orders a chance. If after reasonable time and effort, the orders still cannot solve your issue, you may fill out a notice of motion or order to show cause to go back to court and request that the orders be changed. Until the orders are changed by the judge, you cannot and should not disobey them.
Is there a way to change the orders without going back to court?
Yes. The court understands that as your children grow or your circumstances change, your orders may no longer meet yours or the other party's needs. Parties can work together to come to a new agreement and file a stipulation to modify the court orders.
Can you believe we've been divorced for 6 years now?
It has been a long time, and I'm really glad we've been able to communicate peacefully over the past few years, especially for Veronica's sake.
Yeah, in the beginning it was kind of rough with that restraining order, but I want Veronica to grow up happy.
Well, Veronica's starting high school in the fall, and she wants to play volleyball. Has she told you that she made the team?
Yeah, she was pretty excited about it.
Well, volleyball practices are on Mondays and Wednesdays until 5, and with my new job, it's going to be nearly impossible for me to pick her up. I know you just have weekend visitation, but would you please consider picking up Veronica on Mondays and Wednesdays?
I would love to see her during the middle of the week. Do you think I could have dinner with Veronica? I could have her home by 7:30.
I think Veronica would like that. Would you mind putting this agreement in writing with the court? I picked up a stipulation packet so that we can change our last court order.
That'd be great. Where do I sign?
We just fill out the top here with our information, and then we'll both date and sign right here. And we'll write our agreement right over here.
To complete a stipulation, obtain the appropriate forms from the Self-Help Center, Family Law Facilitator, Clerk, or online at www.courts.ca.gov/forms. Clearly write the terms of the agreement. Both parties must sign the stipulation. File the stipulation in order with the clerk. Provide self-addressed stamped envelopes. Note that the clerk may charge a fee. The judge signs the stipulation and it becomes an enforceable order. To review, a findings in order after hearing is a formal order made by the judge after a hearing. A judgment is a formal order made by a judge after a trial. A restraining order after hearing is a formal order made by the judge after a hearing on a domestic violence issue. In all of these cases, one of the parties prepares the formal order for the judge to sign. Once the orders are signed by the judge, the orders become enforceable. In addition, stipulations are agreements made by all of the parties in a case. Stipulations are submitted to the judge and once signed, become enforceable orders. Court orders are created so that the parties can live peacefully. Court orders are made to decide disputes that parties could not resolve on their own. To avoid further conflict, complete your orders promptly after court and abide by them.